Welcome back to the Deep Dive. Today we're getting into a topic that, honestly, many of us probably put off thinking about. Estate planning. I'm really keen to unpack this because, it sounds complicated, maybe even a bit gloomy. But the sources we've looked at really frame it as a fundamental act of care for your family. There's this idea it's only for the super rich, right? Well, we're going to see pretty quickly why it's actually vital for almost anyone who wants to protect their loved ones and make sure their wishes are followed. So our mission, using the great sources you provided, is to boil down the essentials, find those aha moments, and give you a clear path through it all without getting totally overwhelmed. I'm especially interested in the common traps people fall into, even if they think they've got it covered.
That's right. And what's really interesting, I think, is that estate planning isn't just about, after you're gone. It's very much about control right now and really preventing potential chaos and heartache for your family down the line. It's the legal way you document your really important decisions. Things like who gets what, sure, but also who would care for your kids or who makes health decisions if you couldn't. So yeah, we'll walk through the main pieces that fit together to make a solid plan. Not just what they are, but really why they matter for you and your family's future peace of mind.
Okay, let's start with the one everyone's heard of, the last will and testament, the cornerstone, right?
Yeah.
But for listeners thinking, I don't have a ton of assets, do I really need one? What's the biggest reason, maybe the most surprising one, beyond just dividing up stuff?
That's such a key question, and the answer is often a real eye-opener. A will lets you say who gets your property, your assets, even things with just sentimental value. That's the core. But here's the part that often gets missed, and it's huge. Without a will, you lose the right to name a guardian for your minor children, or even your pets. If you don't name someone, a court has to decide. A judge who doesn't know your family makes that incredibly personal choice. And state law, just default rules, will decide how your assets get split up. It might be completely different from what you wanted. Honestly, that guardianship point alone should be enough for any parent or even a pet owner to get a will sorted.
Wow, that's powerful. The thought of a court deciding who raises your kids instead of you, that really hits home. It makes that act of love point very concrete. And practically speaking, is it a huge hassle to set up? Are there common misunderstandings?
It's usually more straightforward than people think. You can work with an attorney, definitely recommended for complex situations. Or for simpler estates, there are reputable online services now. The key thing is it needs to be signed correctly, usually with witnesses present, to be legally valid. But here's a detail important for our listeners. A will does go through probate.
Probate, okay, what does that actually involve?
It's basically a court-supervised process. The court validates the will, oversees paying debts, and makes sure assets go to the right people. It can take time, it can cost money and fees, and crucially, it becomes part of the public record.
Public record, good to know.
Yeah. So, practical tip, once you have it, store it somewhere safe but where your executor can find it. And definitely tell your executor where it is.
Okay, so a will is essential, especially for guardianship. But what if that public record aspect, or potential delays, makes someone uneasy? Our sources mention another tool for certain situations, one offering more privacy and maybe speed, the revocable living trust.
Exactly. If avoiding probate, keeping things private, or maybe speeding up the process is important to you, then yeah, a revocable living trust is a really powerful option. Sometimes it works alongside a will. Essentially, you, the grantor, transfer ownership of your assets into this trust. But here's the key. You typically act as the initial trustee. So you still manage everything. You still benefit from it all during your lifetime. You maintain complete control.
So you still control it, it's just titled differently.
Precisely. And the critical step is naming a successor trustee. This is the person or entity who steps in automatically if you pass away or become incapacitated. They then manage and distribute the assets according to the rules you set in the trust document privately.
So it's almost like creating a private channel for your assets, bypassing the public court system entirely. What's the absolute biggest advantage that might make someone with a will consider adding a trust, given it's, more work to set up?
I'd say the biggest drivers are usually probate avoidance and the privacy that comes with it. Assets properly funded into the trust just don't go through the probate court, period.
Okay. This means they often get to your heirs faster, without the court fees, and completely outside of the public eye. Trusts are also really flexible. You can use them to set conditions, like maybe distributing money to kids in stages rather than all at once. Or if you own property in, say, two different states. A trust can help avoid having to go through probate in both states.
Ah, it's interesting. Multiple probates.
Yeah, it simplifies things. Now, they do cost more upfront to set up and require some ongoing attention to make sure assets are properly titled in the trust's name. But for people with significant assets, maybe complex family situations, blended families, a child with special needs, or just strong privacy concerns, it offers huge advantages.
Oh.
One quick but important point. A trust doesn't usually eliminate the need for a will entirely. You often still need what's called a pour-over will.
A pour-over will. Yeah, it basically acts as a safety net to catch any assets you forgot to put into the trust or acquired later and pours them into the trust upon your death. So the takeaway. If those benefits like privacy and probate avoidance sound appealing, talk to an estate planning attorney. They can help you figure out if a trust makes sense for your specific situation.
That's really clear, thanks. Understanding where trusts fit is key.
Okay.
Shifting gears a bit, we've talked about documents we create like wills and trusts. But what about things many of us already have set up, maybe years ago, and haven't looked at since? Things that apparently can override everything else we've just discussed. I'm talking about beneficiary designations.
Oh, this is such a critical point. And yes, it trips up so many people. It's almost deceptively simple. You find these designations on things like life insurance policies, your retirement accounts, 401ks, IRAs, even on regular bank or brokerage accounts, sometimes called payable on death or POD. And here is the absolute aha moment, the thing everyone needs to burn into their memory. These beneficiary designations override your will.
Wait, say that again? They override the will?
Yes, absolutely. They act as a direct contract with the financial institution. When you die, the money in that account goes directly to the person named on that form. It bypasses probate, and it bypasses whatever your will says about that specific asset.
Frankly, that's stunning. I think a lot of people assume the will is the final word on everything.
Yeah.
That feels like a hidden landmine in your planning. Can you give us a quick, maybe anonymized example of how forgetting this could cause real problems?
Oh, easily. And sadly, it happens all the time. Let's think about David. David got divorced years ago. He updated his will right away, making his 2 kids his only heirs. Very responsible. But he completely forgot he'd named his ex-wife as the beneficiary on his substantial work life insurance policy back when they first got married.
Oh, no.
Exactly. When David passed away unexpectedly, guess where that life insurance money went? Straight to his ex-wife. His will said everything to the kids, but the beneficiary form trumped the will for that policy. It caused a huge rift, obviously, and his kids received far less than he intended. This is precisely why the sources emphasize checking these forms, and crucially, naming not just a primary beneficiary, but also a contingent beneficiary. That's your backup.
Contingent, right, the backup plan.
Exactly. If your primary beneficiary can't inherit for some reason, it goes to the contingent. It avoids huge potential problems. So the actionable advice here is crystal clear. Make it a habit, maybe annually, or whenever you do a financial checkup to review these, and definitely review them after any major life event. Getting married, getting divorced, having a child, if a named beneficiary passes away. Most accounts let you name multiple beneficiaries too and assign percentages. So you have a lot of control, you just have to use it.
That example really drives it home. A simple form, easily overlooked, can completely derail your intentions. It also brings up another point. Estate planning isn't just about death. It's also about planning for times you might be alive, but unable to manage things yourself. Right. That brings us to powers of attorney and healthcare directives.
Precisely. This is another huge part of that act of love, planning for incapacity. It provides immense peace of mind now. Let's break it down. First, there's the durable power of attorney for finances. This is a legal document where you appoint someone you trust, they're called your agent, or attorney in fact, to handle your financial and legal affairs if you become incapacitated.
And durable is the key word there.
It really is. Durable means it stays valid even if you become incapacitated. A non-durable power of attorney would actually stop working at the exact moment you need it most. So with durable POA, your agent could step in to pay bills, manage your investments, file taxes, maybe even run your small business if needed. It keeps your financial life moving.
Okay, that makes sense. It empowers someone to keep things afloat. What happens if you don't have one? What's the alternative?
Well, the alternative usually isn't great. Without a durable POA, if you become incapacitated, your family typically has to go to court. They'd need to petition a judge to appoint a conservator or guardian to manage your finances.
So, back to court again.
Back to court. It's costly, it takes time, it's public record, and a judge, not necessarily your chosen person, might end up in control. So choosing your agent is obviously critical. Pick someone trustworthy, responsible, ideally someone financially organized, and talk to them about it first. Make sure they're willing and understand what's involved. You can also often specify when it takes effect. It could be effective immediately upon signing, or it could be springing, meaning it only kicks in if a doctor certifies you're incapacitated. Just make sure it complies with your state's laws, and having it notarized is usually a very good idea. Now, equally important on the incapacity front are healthcare advance directives. This is about your medical wishes. These generally have two main parts. First, the healthcare power of attorney, sometimes called a healthcare proxy. This is where you name someone you trust to make medical decisions for you, but only if you can't communicate them yourself.
Okay, so someone to speak for you medically.
Exactly. And the second part is often called a living will, or sometimes an advance medical directive. This is the document where you state your wishes about specific types of medical treatments, especially life-sustaining ones.
So the living will is where you'd say, for example, under what conditions you would or wouldn't want things like ventilators or feeding tubes.
Precisely. You can be very specific about your preferences regarding CPR, ventilators, artificial nutrition, and hydration, things like that, usually in situations where you're terminally ill or permanently unconscious. These documents are just invaluable. They provide clear guidance to your family and doctors during incredibly stressful times. They save your loved ones from having to make agonizing decisions based on guesswork or potentially disagreeing amongst themselves about what you would have wanted.
That really is a gift to them.
It truly is. So, practical advice. Have detailed conversations with the person you name as your healthcare agent about your values and wishes. Give copies of the documents to your agent, your doctors, maybe close family. Some people even carry a wallet card stating they have these directives and who their agent is. Many states now combine these two functions, the proxy and the living will, into one form, often just called an advance healthcare directive. It streamlines things.
Okay, so we have the core legal documents, but what about the more personal side? Funeral wishes, maybe passing on family stories, or even what about our digital lives, our online accounts, social media? Do the sources touch on those practical additions?
Yes, absolutely. And this is where the planning becomes even more personalized. A great tool here is something called a letter of intent. Now, it's generally not a legally binding document like a will. Think of it as a companion document. It's where you can express personal thoughts, explain the reasoning behind certain decisions in your will, give instructions about your funeral or burial, or maybe share advice or hopes for your family, things that don't really fit into the legalese of a will or trust.
So it adds that human touch, that personal voice, alongside the formal stuff, like a guide for your loved ones.
Exactly like a guide. It can be incredibly helpful and comforting for your family. Other things to consider in this vein are making your wishes clear about organ donation, often done via your driver's license or a state registry, or even pre-planning or prepaying for your funeral to ease that burden. And you hit on a really crucial modern point. Digital assets. This is huge now. Think about everything online. Email accounts, social media profiles, cloud storage with photos, online banking, shopping accounts, maybe even cryptocurrency.
Right, there's so much.
There is. So the advice is to create an inventory. List your important accounts, maybe usernames, and instructions on how to access them. You probably shouldn't put passwords directly in the will, but you could use a secure password manager that allows for emergency access by a trusted person. Or store a list securely and let your executor know where to find it. Just organizing all your financial records and passwords in one place is an immense help to whoever has to settle your affairs. It cuts down on so much stress and detective work for them. Again, it's part of that act of love.
Okay, let's quickly touch on taxes, because that's often the first thing people think of with estate planning, right? Avoiding huge death taxes. Is that really the main driver for most people, or is that view a bit skewed?
That's a really common question, and for the vast majority of people, avoiding federal estate tax is not the primary concern. The reality is the federal estate tax exemption is currently very high. For 2025, it's over $13 million per person. So most estates simply aren't large enough to trigger it.
13 million. Okay, yeah, that's most of us covered.
Exactly. Now, there's a caveat. That high exemption level is set to expire at the end of 2025 and could potentially drop significantly in 2026 if Congress doesn't act. So that's something to be aware of long term. And maybe more relevant for some, a number of states, not a majority, but a handful, do have their own separate estate tax or inheritance tax, often with much lower exemption thresholds than the federal level.
State taxes, right.
Yeah. So if you live in one of those states, or if your state is large enough to approach the federal limit, then yes, more advanced tax planning strategies might come into play. things like specific types of irrevocable trusts or lifetime gifting programs. But honestly, for most people doing basic estate planning, the focus isn't really on tax avoidance.
So if it's not primarily about taxes for most folks, what is the main financial or efficiency goal?
For most people, it's really about the smooth, efficient, and cost-effective transfer of assets to their chosen beneficiaries. Primarily avoiding the costs and delays of probate where possible and appropriate. We talked about trusts doing that. But there are other tools, too. How assets are titled makes a big difference. For example, owning property as joint tenants with rights of survivorship means it automatically passes to the surviving joint owner outside of probate.
Okay.
Same idea with bank accounts set up as payable on death, POD, or investment accounts with transfer on death, TOD designations. Those assets go straight to the named beneficiary. An estate planning attorney can really help you look at how your assets are currently titled and see if changes could make the transfer process simpler and less expensive for your heirs.
Okay, this has been incredibly comprehensive. We've built this plan wills, maybe a trust, checked beneficiaries, got powers of attorney, healthcare directives, even added personal touches. So the big question then, is this a set it and forget it kind of thing? You do it once, check the box, and you're done forever.
Absolutely, positively not. That's probably one of the biggest mistakes people make. Our sources are unanimous on this. Your estate plan is a living set of documents because your life changes. Think about it. You get married, you get divorced, you have children or grandchildren, you move to a different state with different laws, your financial situation changes significantly. Maybe someone you named as an agent or guardian is no longer able or willing to serve.
Yeah, life happens.
Exactly. Any of those events could make parts of your existing plan outdated or even potentially lead to unintended consequences. So the strong recommendation is to review your estate plan periodically, maybe every 3 to 5 years is a good rule of thumb, just to make sure it still reflects your wishes and circumstances. And definitely pull it out and review it after any major life event.
That makes perfect sense. So if you have another child, you need to update the will. If you get divorced, you need to check everything will, beneficiaries, POAs. Make sure the people you've named are still the right people.
Precisely. Update guardians for new children. Remove ex-spouses where appropriate, though. Be aware some things, like beneficiary designations, need active changing. Divorce doesn't always automatically revoke them. Check if your named executors, trustees, or agents are still the best fit and are still willing. Maybe their health has changed or they've moved away. Laws can change too. There have been updates regarding digital assets in recent years, for example, or rules about how premarital wills are treated after marriage. Staying current ensures your plan actually works the way you intend when it's needed. And one last point on this communication. It really helps to let the key people know they've been named. Your executor, your proposed guardian, your healthcare agent. Have a conversation with them. Make sure they understand your wishes and know where to find the documents. Good communication up front can prevent a world of confusion and potential conflict later.
Wow, okay. What a comprehensive look at this. We've really covered the full spectrum, haven't we? From deciding who gets your grandmother's china to who makes critical health calls if you can't speak for yourself. It's clear estate planning is fundamentally about making your wishes known and ensuring they're respected. And while, yeah, it might seem like a bit of paperwork up front, knowing there are resources attorneys, good online services makes it feel much more achievable, much more empowering than maybe people first think.
Absolutely. And ultimately, what you're buying with that effort is peace of mind. True peace of mind. By putting these documents in place, you are the one making the decisions about your legacy, your health, your family's future, not leaving it up to chance or state default rules or a court. You're minimizing the potential for confusion, cost, and conflict for your family during what will already be an incredibly difficult time. It really is an act of profound care. So here's something to think about. Picture your loved ones facing a difficult time after you're gone or if you're unable to communicate. Imagine the relief, the sheer clarity they would feel, knowing they have your clear instructions, knowing they're simply carrying out your documented wishes instead of being burdened with doubt, guesswork, and potential disagreements. What steps, even small ones, can you take starting today to give that incredible gift of foresight, clarity, and genuine peace of mind to the people you care about most?